Alimony in North Carolina is going to be warranted when one party is the supporting spouse and the other party is the dependent spouse. How the language is worded is that a supporting spouse shall pay the dependent spouse alimony. A supporting spouse is going to be the spouse that makes a significantly amount more in their income, and the dependent spouse is the spouse that makes less of an income. There needs to be a fairly large disparity in those incomes. Alimony is what the court determines is appropriate to allow the dependent spouse to keep living or maintaining a lifestyle that they are accustomed to living through that marriage. Many times people think that the party that makes all the money should be entitled to their money, and the other parent, who is the homemaker, for example, should not be entitled to any sort of alimony because they haven't worked in that type of situation. However, what the court finds is that party that was working, the party that was making that income, is that supporting spouse, and they really probably wouldn't have been able to do their job as well if the homemaker or that dependent spouse wasn't at home doing their part. So what the court thinks is it's not appropriate to let that dependent spouse just go on and try to live as though they were making that amount, but instead give them some type of support to allow them to live similarly to the lifestyle that they were accustomed to. There's no formula to calculate alimony, so typically what happens is we would have one party, that supporting spouse or the dependent spouse, fill out an affidavit to talk to their expenses. We're going to look at any sort of rental expenses, monthly expenses, what you pay for food for a month, if you go out to restaurants, what you pay at restaurants, if you get your hair done, if you are getting your nails done, things like that are all considered your monthly expenses. So based on that amount, we're going to try to determine what would be a fair and reasonable amount to help that dependent spouse be successful in their life. Typically, alimony is going to be warranted for half the length of the marriage. It's what our courts are typically doing. So if a party was married for 10 years, they're maybe looking at 5 years of alimony. Alimony needs to be filed before the divorce is finalized. What the courts have determined is that if alimony is not filed prior to a divorce being finalized, then that party has waived their right to ever file for alimony. So if you want to file for alimony and you believe that you're in need of alimony, it's very, very, very important and crucial to make sure that that claim is filed prior to the divorce being finalized. Sometimes people will deal with alimony within a separation agreement, but if you have not dealt with it in a separation agreement, you need to make sure that that claim is officially filed with the court prior to your divorce being finalized, or you will lose that right to ask for alimony later on.